Hello, my name is Curtis Mai. I'm a student at Umass Boston, and I'm from Massachusetts. So, speaking from my personal experience, I know that the criminal justice system has evolved since its inception and is no longer a system of ensuring justice. It largely relies on plea bargains so much that 95% of criminal cases are settled through them. A plea bargain or deal is when a prosecutor offers the accused individual a lesser punishment. This can include prison time, fines, rehab, or any other punishment a judge could traditionally order without facing trial. How the deal is negotiated is kept privately and mostly undocumented between the two parties. There are also no criteria or rules for how a plea deal is struck. It is a black box of judgment. So why is it a bad thing? Well, they give prosecutors an inordinate amount of leverage to coerce the defendant to take a deal. Some tactics they use to coerce defendants include tacking on additional charges that can be punished by death or life sentences, threatening family members of facing trial as well. There's also nothing stopping prosecutors from withholding information that may or may not change the defendant's decision. Personally, I got a good deal, a year-long restraining order from the plaintiff, and while that was maintained, the case would be left open. The prosecutor, however, failed to disclose that they had zero evidence because the plaintiff wasn't willing to testify, and that until the case closed, I couldn't pass a background check. Had I known these things, I might have tried court. The only reasonable solution to this issue is by requiring prosecutors to document the bargaining process to protect both them and the defendant. By increasing transparency, it gives the defendant reassurance that the prosecutor does not go beyond reasonable means to reach a compromise, and that later, when the defendant is facing their end of the bargain, they cannot claim they had poor legal counsel. Thank you.